Good morning, everybody. Just this morning, I saw a video posted by Mystic Jinx Thinks. I'll leave the link to it. I'm sure that there are very few of us within the Making a Murderer community in support of Steve and Brendan that think highly of either Wendy Baldwin or the majority of the Calumet County Sheriff's Department. Wendy Baldwin, of course, is the one that's famously heard routing through Steve's letters and shoes, and then comes across a letter and says that this is a letter from the inviting Steve to an exoneree's luncheon, and sarcastically saying, "I don't think he's going to make it." It's terrible, the language on the video where they're burning in a bonfire. I'm not too sure exactly what it was to begin with, but it might have been an effigy of somebody. And you know, it really does make you wonder about. I came across an article. I think this again was from the National Association of Criminal Defence Lawyers, or it might have been posted on the Blind Injustice site by Mark Godsey. I can't remember which. I do apologise. But here's an article. A very recent article that deals with police qualified immunity. You know, on the one hand, yes, we do have respect for the police. When we hear the sort of language being used by Wendy and her pals, it's difficult to side with them. Qualified immunity. Supreme Court sides with police, overturns denial of immunity in 2 cases. So in 2 cases, the police were denied immunity, but then the Supreme Court has decided to come down in favour of the police. I mean, if they were to hear some of the language being used, they would realise. Also, one of the interesting things here is that there's one of the first case is to do with somebody being shot dead by police in a kind of a self-defense way, but certainly not the way that, for example, Michael Funk was just basically executed by Officer Hoffer. Anyway, let's have a look through it. Qualified immunity. I know this is something that we're particularly interested in. Qualified immunity for police, absolute immunity for prosecutors. It's ridiculous. Washington, the Supreme Court sided Monday with police. Oh, sorry, let's have a look. Have we got a writer of this article? Yes, John Fritz of USA Today. Washington, the Supreme Court sided Monday with police in 2 cases in which plaintiffs claimed officers used excessive force, overturning separate lower court rulings that had allowed the officers to be sued for civil rights violations. In 2 unsigned opinions, the court stressed police were entitled to be shielded from liability unless it is, quote, clear to a reasonable officer, unquote, that their actions are unlawful. In both cases, the court ruled that the officers were entitled to qualified immunity, the legal doctrine that protects police from liability for civil rights violations in many circumstances. In one case, the Supreme Court overturned a lower court ruling that found an officer in California who placed his knee on a prone suspect could be sued. In another, it overturned a lower court ruling that 2 police officers in Oklahoma could be sued because their actions before a fatal shooting escalated the potential for violence. At a time when the nation is still grappling with fatal police interactions and bipartisan talks in Congress over increasing accountability have fizzled, the Supreme Court has mostly balked at lawsuits questioning the legal immunity extended to officers. Critics say qualified immunity lets police off the hook in virtually every case in which their actions are not specifically prohibited. Police organizations have long countered that officers need immunity in cases when they must defend themselves and split-second decisions can lead to unforeseen tragedy. There were no dissents from any justice in either case. In one of the lawsuits, two officers in Oklahoma were part of a group of police that responded to a 911 call from the ex-wife of Dominic Wallace. The 49-year-old Wallace was in the garage, his former wife told police, and was intoxicated. Police walked into the garage through a side entrance and confronted Wallace, who moved forward toward the back of the room. Body camera footage shows that at some point after Wallace reached the back of the garage, he grabbed a hammer in one hand and held it above his head and put his other hand in front of him as if to signal the officers to stop or to create distance, according to court records. Police drew their weapons, but soon after one of the officers is heard saying he would quote, go less lethal, unquote, and switched from a handgun to a stun gun. Wallace's attorneys have called attention to that decision as a sign the other officers also could have holstered their weapons. Police repeatedly demanded that Wallace drop the hammer, but he declined. Wallace continued to talk with the officers relatively calmly, according to a lower federal court's account, but also appeared to pull the hammer behind his head at one point. In response, two of the officers fired their weapons multiple times. Wallace died of his wounds. The state medical examiner later found methamphetamine in his body. Now, Wallace's estate sued the officers, asserting their conduct violated his civil rights. A district court ruled the officers were entitled to qualified immunity, but the Denver-based U.S. Court of Appeals for the 10th Circuit reversed that decision, ruling that courts may consider police conduct in the moments leading up to a fatal encounter if that conduct created the need to use force in the first place. Because appeals courts across the country have dealt with that question differently, Wallace's attorneys appealed to the Supreme Court seeking a nationwide standard. Quote, the officer's conduct, aggressively moving in on an impaired person and backing him into a garage full of tools, immediately inflaming the situation and causing him to pick up a hammer, was indeed reckless behavior, attorneys for Wallace told the court. Lawyers for the officer countered that they tried to de-escalate the situation and repeatedly Wallace to drop the hammer. The appeals court decision, they told the Supreme Court, leaves police in an untenable position in which they face liability for being branded unconstitutional actors, even if they act reasonably in self-defense. Officers deserve better than to be put in that no-win position, the lawyers said. Well, the obvious point there is that one of the officers said, not to go lethal. It wasn't as if he had a gun in his hand. He had a hammer. They had tasers. They could have dealt with the situation there and then. But the fact that the guy is talking coherently, just incredible overkill, isn't it? Anyway. In the other suit, police were sent to a home in Union City, California, near San Francisco, 5 years ago after a 911 call in which a 12-year-old girl reported that her mother's boyfriend had a chainsaw and was going to attack her and her family. Not a good situation. When police arrived, they spotted a knife in Ramon Cortez Luna's pocket and shot him with beanbag rounds when he lowered his hands in apparent confusion at the orders police were shouting at him. A divided U.S. Court of Appeals for the 9th Circuit reversed a lower court's judgment for the officer, ruling that controlling precedent at the time put police on notice that kneeling on the back of a prone, non-resistant suspect was considered excessive force. Attorneys for the police told the Supreme Court in a brief that the kneeling move used on Cortes Luna is, quote, standard field procedure. The officer appealed to the Supreme Court in May, asserting that briefly placing a knee on a prone suspect was not excessive and that the tactic is, quote, employed hundreds, perhaps even thousands of times each day by law enforcement officers throughout the country. Well, that's quite honest of you, of the officer, yes. The lawsuit is one of several challenging the police tactic of pinning prone suspects. Earlier this year, the Supreme Court sent back to the lower courts a suit against St. Louis police brought after officers handcuffed a man and put their weight on his back inside a jail cell. I mean, look, obviously, if you're being arrested, don't try and resist. But I think it's obvious that you don't put your knee against people's necks and backs and stuff like that. Anyway, as usual, let me know what you think about it. This qualified immunity for police officers. To me, it seems as if there were clearly, in the deadly shooting case, there was at least one officer that realized that, you know, things needn't escalate. He could just use a stun gun, a laser gun, taser, end of situation. And yet they decided that they would unload their weapons multiple times, which again reminds us of Michael Funk, you know, not just shot once, but 18 times. And as I say, do check out Misfit Jinx Thinks' video, which I will put in the link below. I have seen that video before. As I say, her attitude towards other people as a former, I think she's former now, as a former law enforcement agent is pretty appalling. And you get the impression that, you know, it's the norm within the police force, this kind of attitude of theirs, that they have this immunity, they can do what they like. Let me know what you think, and we'll catch you all again soon. I've got something a bit more cheerful lined up as well, so I might get that one done today, or it might be tomorrow. Catch you later. Bye for now.